let's start. I think we can start our conversation for our colleagues who just enjoyed to us. We have a fourth panel discussion of social justice and digital economy conference. It's part of Cyber Scotland Week and organizer National Bar Association of Ukraine and me, official representative in Scotland. Why Scotland Cyber Week? And European Young Bar Association and UMDC, Ukrainian Modern Digital Science NGO, and Ukrainian State Institution Economical Legal Research of National Academy of Science, name it, academic Mamutov. So we have three experts from our panel. And for start, I want to invite for short presentation about your companies. Let's start from Philippa Wilkinson, SRM company. It's famous investigation, intelligent detective company in crypto world. And it's really honor to us see you today in our event. So you have a few minutes for short presentation and main idea of your company. Please.
Thank you very much, Alexander, and thank you for organizing the day today. It's a really interesting session. So SRM is a cybersecurity and corporate intelligence firm. Our cybersecurity team is working every day on incident response, on ransomware cases. So they build up a huge amount of knowledge about that side of the cryptocurrency ecosystem. I sit on the corporate intelligence side, specifically on the disputes and investigations team, where we help clients who are the victims of fraud, who are in commercial disputes. And one of the things we do with these clients is asset recovery, including looking at cryptocurrencies. I'm afraid I don't have a presentation, so that will have to do for the introduction of SRM, apart from to say that we're regularly working in Ukraine and, hope to be, doing so in the future. So we're delighted to be kind of participating in this kind of joint UK or Scottish Ukrainian event.
Maybe presentation not so important as your answer for question, because I collect very complex and very interesting question for all of us, and all of our experts free to answer any questions. And please, I'm really happy to see our colleagues. No, sorry. Oh, my signal. Okay. Our colleagues from Canada, Carolyn Vale. Nice to meet you. And please, your presentation about your company, about legal leader of recovery and disputes with cryptocurrencies.
Hello and good afternoon, everyone, and thank you for the lovely introduction there. So my name, for those who don't know me, is Carlin Wheel, and I'm a legal director and I lead the commercial disputes team in our Manchester office at Kennedy's, an international law firm. As part of my role, I set up our recoveries unit in 2018 and had a growing interest in recoveries arising out of fraudulent transactions, arising from ransomware attacks or other fraudulent activities. Sometimes that is ex-employees of companies or third parties, or sometimes it is a threat actor and an anonymous persons unknown. 2 years ago, together with my team, I secured one of the leading injunctions against persons unknown. That was a worldwide injunction to prevent the dissemination of information downloaded on the dark web belonging to a law firm to other third parties, or for it to be purchased and used. My team are also responsible for putting together a product to look at the specific recovery of crypto assets where ransom payments have been made as a result of cyber attacks, and working together with Philippa and others to try and identify those assets and look at the steps that we can take to recover them. Now, I don't think anybody wants to hear from a lawyer the blow-by-blow account on steps I can take to satisfy a High Court injunction, so I think that's probably enough from me now. But if you do want to raise any questions about what the process entails and the prospects of recovery, then I'd be happy to answer them. Thank you.
Thank you for your presentation about your company and your experience. And next will be Nico Demchuk. Sorry, Paul, Nico was first. And connection now. Happy to see you. Nico, please, about your company and your experience.
Yes, sure. So my name is Nico Demchuk, and I'm also coming from legal side. So I'm a lawyer myself and compliance specialist at AML Bot. AML Bot is a blockchain analytics company. So we do provide crypto screening services where we screen crypto addresses and crypto transactions on AML risks, as well as KYC, consulting, and crypto investigation. So we have a special department that focuses on tracing funds of the victims. It's been an interesting year for us. We have some successful cases that I'm about to share. We have around 6 successful cases where we help our clients to return their stolen funds. We also build very good connection in US and India with the law enforcement bodies, so it will assist us very quickly to freeze the funds on centralized crypto asset service providers if it's needed. And in general, we're expanding our network. So we want to help our clients as fast as possible to freeze the funds, and then it will be, of course, up to him and up to the lawyers to start the process of a recovery. But it also depends on the jurisdiction. So far as this industry is only developing, there are many, what I see in the market, that depending on where the crypto asset service provider is registered and regulated, on which countries the process might be easier. They might return funds or stolen funds much easier, or the process might be very complicated and time-consuming, especially if it's a regulated, very well-regulated jurisdiction.
Thank you, Nico and Paul. We are all happy to see you, and short presentation about your company.
Yeah, sure. Thank you, Alex, and thanks for inviting today, and great to be on such a panel. Sounds like we have a lot of synergies between all of us here, especially from the two intros that have just been given. So yes, I'm currently the head of sales, so I come from the sales side, obviously, but that contributes to working with a lot of the legal, compliance and operational side of crypto businesses. The company I work for is Global Ledger, and we are very similar to Nico in the terms of we do a lot of AML screening, transaction monitoring, and obviously blockchain visualizations. That would be, more on the AML side of what we supply as compliance solutions for compliance teams within the crypto industry. We also do another service, obviously providing of investigations for any illicit activities or stolen funds. And that obviously entails quite a lot more heavier due diligence, both on-chain and off-chain. But yeah, generally speaking, we are involved with a lot of financial crime organizations, government organizations, authorities, and we do provide trainings to cyber police units, like I say, financial regulators, and generally try to encase that all in what we offer for services. Prior to being with Global Ledger, I've been in the industry for around almost 6.5 years now. I was working for another AML provider under the name of CoinFirm, who have recently been acquisitioned by Luca. So very heavy on the data analytics side from there as well, obviously, with a good sprinkle of AML and KYC services that come alongside that. We're looking to obviously break into the different markets, but European being one of our more, let's say, prevalent areas of the continents when it comes to the granularity of the data, and obviously being very close to home with some of the team in Ukraine, you know, in terms of sanctions and PEPs and what's coming out from Russian states as well. So yeah, very happy to be on the panel and share some experiences, some horror stories, and probably you know, some similar accounts of what we've seen in the industry.
Thank you very much. And short question, maybe not sure. It will be extraordinary question. What do you think about last Satoshi mail last week about, sorry guys, blockchain, it's not so confidential and anonymity as I talked 10 years before. It's helpful for our work in investigation, or is maybe it's not a secret for professional because anonymity of blockchain. Who will be first?
Well, sorry.
Please. Right, it's all right. Please go ahead.
From a lawyer's perspective, it's obviously very positive, because the issue that we have is that we can have some fantastic legal claims and we satisfy all the legal tests, but ultimately, what is the objective? And if the objective is to protect information as best we can to obtain an injunction, then that's one thing. But if it's to ascertain and establish and get paid on a recovery, then that's very different. So the more information that's available to us allows us to advise clients to the extent that we think a recovery is possible. So I see it very much as a positive from a legal perspective.
I was just going to chime in with a joke and say you might want to ask Mr. Craig Wright if it's got any relevance to his trial at the moment, because that's obviously been in the news recently as well. I think the timing probably couldn't be better in this situation. So yeah, from that side, I believe, you know, there's also been in that particular case, we can see potential manipulation as well of certain documents. And I think, you know, anything that comes from a trusted source, if we can call it that, a trusted unidentified source, you know, it makes quite the headlines and rings through, you know, through all of the sides of the industry, especially as you just mentioned, you know, coming from the legal and the reclaiming of assets side. But yeah, big news. You know, industry eyes open, and everybody's sort of waiting to see what happens from here.
Oh, thank you, Paul. Philip and Nico.
I think, you know, it's interesting news. The transactions on the blockchain or wallets addresses have always been pseudonymous, really, rather than anonymous. So, you know, you can use the kind of technology that my co-panelists provide, and you can map an individual's footprint on the blockchain, and you can understand, you know, the wallets they're using. The challenge for us is then to connect that to a real group or a real person that we're looking into. So any material that helps us do that, we'll always look into, but we look into it with a critical eye. You know, you have to take a sophisticated and nuanced view of these things, and not just assume that you know, you can easily identify wallets and that kind of thing. But it's definitely interesting news.
Oh, thank you, Nico.
Sorry, totally agree with the previous speakers. I think blockchain analytics services that provides more clarity on what is going on in blockchain, who are those senders and receivers of funds, actually attracts more good actors in the industry, as well as now we see that institutional investors are more interested because, of course, regulation, and also because we know many companies also have the tools to prevent cryptocurrencies being used for some illicit activities.
Oh, thank you. Next question for all. Because I'm a lawyer from financial sector, from banking sector, and working with not-profit loans, it's my experience for last 20 years. So if compared with other types of financial collection, financial collection of phones. How real has a collection of cryptocurrencies become? It's real now, it's working now. Who will be first? Because why is this very simple question for you and maybe not standard, but in Ukraine, it's a new area of legal practice, and it's like from sphere of astronaut, from space, and most of Ukrainian advocates don't know about this, and even not understanding first steps, and we're trying to show it's real. Guys, we have experience, we have a new ocean. Maybe we not have biggest shark in this ocean, but we are calling today big shark from this ocean. So it's a real collection and litigation in cryptocurrency assets now.
I can start if you like. So from the perspective of an investigator, compared with your conventional asset tracing, it opens just a huge amount of opportunities to our investigation. You have the huge amount of public data that's on the blockchain. Obviously, you do need those platforms, the technology to help you analyze and interpret that. And even with that, it's still a challenge. But that basic methodology of tracing transactions through the blockchain is widely accepted. Everybody can see and verify these transactions that have been mined or approved. So it's all verifiable. You just need to have the right tools to understand, the transaction hashes and the wallet IDs and put that together into a readable form. And that means instead of having to go out to each bank with a disclosure order, wait for a response, however much that costs you in legal fees, you can map the history of a flow of funds. You can watch it happen in real time. If you're fast enough to kind of catch funds that are still on the blockchain, you can monitor those wallets and watch the funds and react to that. And that means that you can trace stolen funds. If in theory, you can trace stolen funds very easily. The practice of what we find is that increasingly the money laundering is becoming much, much more sophisticated, that you're mapping hundreds of wallets. When we look at ransomware, where the money laundering is a given, is a part of the operation, it's incredibly sophisticated. We're looking at hundreds of wallets. We're looking at various different actors involved. And, it becomes more time consuming to map. It becomes a bit of an arms race between the money launderers and the investigators. You're looking at, questions of how you evidence that more complex flow of funds. In close collaboration with the legal team who can kind of communicate and react and use the information that you're providing, I think absolutely it's a real thing that you can persuade the courts to freeze the funds. You can persuade exchanges and courts to return those funds. If you understand the sector, if you understand the patterns of money laundering, and if you have the right team on board, both the legal, the investigator, and the platform.
And in terms of actually running the action itself, what's very interesting in these types of applications, because they're against an unknown threat actor, whilst there is some sympathy to the criminality of the activity behind there, we do still have to establish, as expected, with full and frank disclosure, the circumstances relating to the incident, where exactly the funds can be located or where we think it can be, with sufficient particularity in order for the judge to be able to make the order. So there is still a lot of work that needs to be done. It hasn't eased the legal process, and neither should it, because it's there for a reason, to ensure that it comes up to proof. But at the moment, we're examining a number of test cases to test different ways in which we think we will be able to establish quite a number of recoveries. But as you said, Alexander, it's very much in its infancy because it's such a novel concept, whereas the other types of cyber injunctions now have been going for about 3 or 4 years against persons unknown, but they arise more in respect of ransomware attacks and the preservation of data. This is something very different. But as people thought a few years ago, you would never be able to tie down assets from a fraudster, and there's all sorts of confiscation orders and pension pots and everything that we're clawing back in, and charging orders, etc. It will come. It will just take time to evolve.
Super, thank you, colleagues. Maybe you have some words about Paul, Nico?
Yeah, sure. So definitely completely agree, you know, with what's been said. I think as well, you know, it's the regulatory imbalance between jurisdictions, which I know, Nico, you touched on, you know, at the very beginning, you know, in terms of the actual process of this working. Once again, having the right legal team in place that actually understands what to do with the on-chain evidence to prove that in courts, and then potentially a judge with an open opinion, you know, in the courts that can understand that. But I think, yes, there's definitely, you know, I've worked with numbers of solutions and professional investigators that have, you know, made more than a case. I don't think necessarily the solutions and the industry is in the infant stage. It sits more on the legal side and with the financial regulators, and I'm not blaming them for having, you know, a treasure chest of money to be able to train and get everybody up to speed with this. But with regulations that have come in more recently, situations that have happened over the past year, you know, I won't name the bad actors, as we all probably know who they are. I think it's really sort of, let's say, crack the whip a little bit to up this process in terms of getting assets returned, you know, when wrongfully taken. From my experience of working with lawyers and supplying the on-chain evidence for cases, you know, it's never a short process. I'd put my head on the chopping block and say the quickest you turn around is you know, a 3-month period. I've heard of much longer investigations going on. There are some companies out there. One to mention is Asset Reality and Aidan Larkin, who've been doing some great work, working with the FATF, Interpol, Europol, and working on some really big seizures. Them partnering with the likes of MetaMask and Phantom, you know, it really does help when you're looking into the dissipation of funds from illicit crimes, you know, whether that's cyber theft or whatever that might be, even internal collusion in some cases. You know, if I can rewind back to sort of 5-6 years ago, we would monitor closely on hacks and situations, and we would turn up to the exchanges with the evidence, and 7 times out of 10 they would be pretty responsive and be like, you know, thanks, wow, you know, we were tracing it up until a certain point ourselves, but we couldn't see through, you know, said mixer or said tumbler or however that looked, and sometimes we had no replies at all, and that normally meant to us that it was probably an inside job. So they didn't want us sort of sniffing around too much. But yeah, it's come a long way. Yeah, and I do see a very positive future. Like I say, it's more where you can pin it to jurisdictionally, where they're actually going to be able to take action. And like I say, having the right legal representation and your evidence presented gives you much more of a solid case and a good chance of getting a good chunk of the funds back. So that's how I'd sort of describe where we are today.
No, better future for our clients. It's no fraud, but a better future for lawyers and investigators. A lot of fraud in the cases in Nico. Maybe you have some words.
Yeah, I would say like this. A couple of years ago, 4 years ago, I think it was really difficult to talk to law enforcement bodies and to explain them what is going on. For example, if the victim came to the police and tried to explain, my funds were stolen or I was the victim of the scam, etc. Very often they did not understand what the victim is talking about. So whereas right now it became really easier to communicate with law enforcement bodies, and I do say about different countries, because when we have a victim, it's usually from different jurisdictions, US, Ukraine, the Middle East, Europe, etc. Now they actually understand what is cryptocurrency, that there is also blockchain analytics services that can trace the stolen cryptocurrency. What does it mean? So one of the aim at AML board that we have is also to kind of educate police, educate law enforcement bodies. So we actually explain them what is going on, that there is a transaction head, there is a victim address, and if you want to send a subpoena or request, you need to send a deposit address. So we are working closely with them, educating them, and now we see the results. Now it's easier, for example, for a victim to initiate the criminal case. Also, on the bad side, the recovery process is very fragmented, depending on where the crypto asset service provider is located, regulated, etc. And from our experience, we see that it's much easier to actually help recover funds if it is some crypto asset service provider registered and BVI in some of these offshore jurisdictions. They are much more easier to cooperate. They can even return funds on the request of the police, etc. While if it's a regulated CASP registered in Europe, or if it's a very big centralized exchange, then the process is very burdensome, complicated. They're not very responsive, as they also expect a court decision, etc. And that's where the problem starts. Because the process usually then to get this court decision is very long. I know maybe my colleague can also talk about this. But when it comes to the court, then it's where it actually stops or puts on hold because it's develops and going very, very slowly.
Thank you. My next question for my colleague is for Carlin and Nico. First contact with client. As client understands, oh, I lost my money, I lost my crypto. As I understand, clients first of all turn to solicitor or advocate in Ukraine when they realize that they have a problem with the search, arrest, recovery of crypto assets. What are your tips for a client to make your first meeting effective, more effective?
Well, I think it goes back, and it's probably a slight tangent to the question, but I think that we work a lot with our cyber team about risk management in advance. So the more that people are aware of the issues and the more they're live to the issues, the more they can prepare for if in case of crisis. And one of my areas of work is shareholders disputes. And the first thing I will always ask when somebody comes in is, do you have a shareholders agreement? And quite often the answer will be, no, we didn't think it was worth it at the time, or we sort of have this, but it doesn't quite match the figures. And it's the same thing. It's okay, where is the information? What information can you provide us? And what steps can we do as quickly as possible? Because there is a need for speed on these matters. You have to act very, very quickly. So the amount of information and a narrative of the background, it doesn't need to be a full essay, just some factual basis in which we can get to the real nub of the issues to translate into a court application is exactly what we need, because the court work on facts and not on the emotion of it. It is a terrible situation for anybody to be in. But the court application and the hurdles is what we have to focus on straight away, and how to get that information. And what we would do is pull in the professionals as soon as possible on day one to skill up as a team so that everybody can complement each other with the expertise that they have. And therefore the client then feels that they're being well represented from a number of different ways from the outset. That might be forensics, that might be PR, that might be any manner of data analysts, and our good panel here, of course. So I think that's the best thing is look at the facts. Very, very difficult in those circumstances to do that, but very, very necessary, because the law in the UK is about the facts and the circumstances in each and every case. And the fact that somebody else has got an injunction means absolutely nothing at those initial stages. It's quite helpful in court to rely on other authorities, but each case is tested on its own merits. Hope that helps. Oh, you're on mute there.
Thank you very much. Very good answer. I think it's helpful for us, Nico.
Nothing to add here.
Brilliant. Next question, more difficult for Filippo, for Paul, and for Nico as a part of investigative group. Instructions as solicitor of advocates without going to technical issues of search and investigation. What technical and organizational details would you advise to pay attention to when talking on each new case? Your recommendation, what some evidence, detailed information for the technical part should collect your client before first meeting with
the absolute essential thing to have is some kind of start on the blockchain, whether that's a transaction hash or a wallet address where funds have been transferred from the victim to the criminal group or threat actor. You know, that is a starting point to start kind of mapping the flow of funds and analyzing what's on the blockchain. I mean, I can talk a little bit later about identifying transactions without that information, but if anyone comes along and tells you that they can just find your threat actor or your criminal group on the blockchain without any of that unique identifiers of the transactions, then you know, walk away because they don't know what you're talking about, because that's just not a realistic, you know, reliable way to operate. So, you know, then we can start analyzing this flow of funds. Then we can, you know, start looking for fiat off-ramps. Those are like the choke points in terms of the crypto world, when an individual or group is trying to transfer funds from the blockchain into fiat currency. It's a point of vulnerability because it's a choke point. And if you can identify where any point that they're doing that, any relatively regulated exchange, which is going to be responsive to court orders, to disclosure orders, to freezing orders, then that's your aim. So you've kind of got those 2 points and you're trying to map your way between them. The other thing you really need is just to have that communication open with the client, the victim that you're working with the legal team and with the investigative team, so that, you know, information is flowing, so that you don't miss opportunities, so that, you know, you're acting in a prompt way when there is an opportunity to look at those areas.
Yeah, I think I'd completely agree with that. I mean, time being, you know, one of the most crucial factors here. So I think, as well as Carolyn said, you know, giving that consultancy in and around, you know, breach or attack or hack, whatever it might be, that leaves the victim or the company vulnerable. You know, sort of self-awareness a little bit more on their part, but I think it doesn't really become a reality until the threat is there. And like you say, you have to be ready in these instances. So that would mean having all of the components that we've gone through, i.e. legal, the forensic on-chain evidence, you know, and a route to law enforcement, somebody who knows somebody who's actually capable of dealing with this at much higher levels. I think it's, you know, the advice I would give in that essence would be, like I say, to have this network and chain of professionals and service providers and vendors in place, ready for that to happen. You can never say anybody's 100% safe. You know, these things can happen in a number of different ways, of companies being breached, normally via email, some sort of attachment, or one of the most majority ones I've seen have been like somebody impersonating a member of staff within the company and reaching out to somebody saying, "Oh, I need to speak to you urgently. Here's the meeting link," and they've just opened, you know, a whole can of worms when it comes to systems being breached or jeopardized. So yeah, it boils down to having those open channels. And that would definitely be the advice, especially in the jurisdictions where it's more prevalent and results are delivered. And like I say, you're going to have stand much more of a chance. I think it's also worth to note, you know, the longer that these from start of the illicit activity through to however long that goes on for, the quicker it is, the more transactional hops they do and the more dissipation of funds, the harder it becomes for the investigators, the harder it becomes for the legal to present the evidence, and the less understandable it may be for the judge as well. So it really is a case of, yeah, having those lines. There are collective white hat groups that have secret members that work in different exchanges that I know of, that sometimes that can help get funds frozen quicker or for longer periods of time with, like I say, the backing of any court order or legal evidence that's submitted. And yeah, the exchanges weren't necessarily ones playing ball so much in the earlier days, but now obviously due to licensing obligations, you know, regulatory improvement, and then just basically not wanting to be labelled as money launderers or criminal traffickers, it kind of makes them act a bit quicker and be a bit more cooperative, which also then in turn gives the chance to law enforcement to actually go in and do a deeper dive if they really need to. And make sure that the end result, you know, comes out in favour of the victim or the company that's been affected. Sorry.
Thank you. Welcome to Evgeny Panchenko. He's just joined to our conversation, head of Department of Cyber Police of Ukraine. He's also a very high-level expert in investigation. He's an official government investigator. So our next question for all, knowing your expertise and experience, can you describe the main problems which counter it in cryptocurrency cases, dividing them into groups: legal question, technical question, and organizational question? When you start investigation, main question and main difficulties: legal, technical, organizational.
So I think I've spoken about some of the risk factors anyway previously, but I think something we've not touched upon is something that I will say to all my private clients where there's no cyber relationship in a case, and it's only go for matters where you think there's a prospect of a recovery, because ultimately if there is no prospect of recovery, you can have a court order that's of little effect or use if your objective is to recover monies. And I think that is going to be the hardest. And I'd be interested to hear the investigative side of this, because I know that you'll know more about us and to what extent you can recover. But that would be my biggest warning. So you have to start when you're running a legal case with the end. What does the end of this look like? Is there a realistic prospect before somebody spends thousands upon thousands of pounds in trying to recover something of recovering it? And if it's a question mark, is it worth the risk? And I certainly see that the opinion is changing in terms of whether it's worth the risk. There's a lot more appetite now to look at the recoveries because, again, the number of substantial ransom payments, just by way of one illustration. So I think that is something that we need to be very mindful of. The other key aspect for me is obviously identification of the assets, but Philip has already spoken to that, which is obviously highly relevant at the outset of the case, is identifying what you're looking to freeze, because you need to know.
You know, we have one joke in Ukraine. It's main trouble of photo hunting. You know, when we're making photos of some animals, half of the day you run for find your model, and another half of the day you run to give photo for your model. It's same situation in cryptocurrency. If you cannot find final result, no case. So maybe colleagues, you have some ideas.
Yeah, I can also add here in terms of legal problems, what is the most complicated one. When it comes to the funds recovery and the cyber crimes, it's always an international crimes most of the time. So it means that many jurisdictions will be involved. So A victim would be living in one country, he might be the citizen of another country. Then the funds were sent, we don't know to whom, because it's difficult to understand who is behind the others. But once the fund ends up, for example, at a big centralized exchange, Binance or whatever, then it's also difficult to identify which jurisdiction this central exchange is which jurisdiction is actually accepting the funds, because Binance has many companies all around the world, as well as other big crypto exchanges. Then it becomes a problem with whom actually communicate. Good that you have one channel in case of Binance, etc. But sometimes it's difficult to understand. And then when the legal case will start in the court, it will be also problematic. So it will start most probably where on the country where the funds are now being held by the centralized exchange, or on the country where the victim resides. So I would say this would be the legal problem, the biggest one. And of course, different countries have different rules. So we see that the law enforcement approach our cases differently depending on where they are. In terms of technical, of course, for investigators, when we are talking about mixer, when we are talking about bridge swaps, especially to blockchains that cannot be traced, or there is no company that can actually understand mark the addresses and know to whom the address belongs, then it's a technical problem. And in terms of we have the organizational one. I think the speed really important in our cases. Once the victim, for example, comes to us, we can easily mark the address and then notify all other blockchain analytics company and big centralized exchanges via the one channel of communication that everyone, I think most of the people are members of. So this address can be easily flagged. And once it appears, the funds ends up on the central exchange, they will be blocked. But different exchanges have different approaches. Some might block only for one day and then request the victim to send the police report. And in one day, it's almost not possible. And we had cases where it was only one day and the victim went to the police, but it was done in 7 days. So once in 7 days, the victim sends the report, or the police sent the confirmation that actually the case was open. The exchange said, sorry, but we allow this user to withdraw funds because it was over than 1 day. So that about organizations, that different approaches, you need to act fast, etc.
So you're all very brilliant speaker, because we are like a football team. You just pass to me ball for my next question. It's of course it's not about my sympathy for United Kingdom, but if chosen from jurisdiction, if you chose a jurisdiction to regulate cryptocurrency issues or dispute resolution, why would you recommend it United Kingdom law, English law? Because Scottish law is another part, and we will talk in the next panel with advocate from Faculty of Advocates, Kenny Young. He will talk about one very wise practice in Scotland when they can work with artificial person and responsibility of artificial person. So why UK? For your opinion, why UK may be better jurisdiction for these cases?
It's a very sophisticated legal system. It has a lot of exposure to relevant professionals that are based here. It can keep costs down accordingly. in terms of injunctions, I wouldn't. The court system is not particularly swift at the moment. They haven't really recovered from the COVID backlog, and therefore there is quite a wait for final injunctions and trials. But actually, when you have a matter of this nature, the court pick it up and deal with it instantly. There is a daily applications list. There is a 24-hour hotline. There are hearings put aside every single week. There are precedents and authorities and brilliant minds, as there are all over the world. But I also think that the ability in the UK or in England and Wales that I can speak to enforce a worldwide injunction has a greater ability and visibility than in other jurisdictions. I can't say which ones, I don't speak to those, but I know that in terms of obtaining a worldwide freezer, what you can do with it and enforcement overseas can often be easier, whether that's to do with conventions, certain agreements, or whether it's a more recognised legal system. I do think that it has a lot of benefits to issuing here.
And also precedent, positive precedent. And Evgeny have some question. Please, Evgeny.
Yes, thank you, Alexander. Yeah, I just will also add some words about the previous questions, because it's so, like, complex, the issues that we have in probably investigation or analytics process, that we have some virtual assets was stolen or other ways to included in our case. Yeah. So in Ukraine, yeah, we have also probably really good practice and knowledge about that. So about technical, yeah, of course, it's about, first of all, it's about the tools. So we know that many tools today really powerful, but at the same time, it's not like complex, you can find different attribution in different tools. So it's just tells that you need to have all tools. All you need to be sure that your tools that you chosen gives you the more resultative attribution. So it's always challenge, because for now in Ukraine we don't have any special tools. Of course, we have one of our vendors who also produce the not bad analytic tools, but they not cover all exchanges that we have in Ukraine. And it's big challenge for us, because sometimes you can see really huge amount of funds that flow through some addresses or clusters, and you can understand that's probably exchanger, but you not see the name, you can't recognize that. So you need to make some intelligence for that, and of course you spend time. And as Nico said, that yeah, we spend time, so the assets should probably withdraw, and we again need to make some new intelligence or analysis about the next addresses and so on. It's first of all about technical issues. Of course, many issues about the legal ways how to size the fonts. It's also a really big discussion, because in different jurisdictions we have different statements about the seizure and arrest the fonts. Many ways how to do that. In Ukraine, we're not organized now that. In our legislation, we don't have any articles about that. About organized, yeah, the intelligence, the investigations, and our activities, yeah, probably it's the more how would say, it's not so trouble area, yeah. So we know that we need to work with virtual assets and not expect the regulation probably tomorrow. So yeah, we organized our team and our activities as we can. So just based on the regular criminal code, criminal procedure code, and other things. So we don't like to break the law, but at the same time we also need to react on the crimes that committed with virtual assets. So it's the second part of my answer, and the third probably it's about legislative. So yeah, we also have some ideas how to organize our legislative. We sent some advice to our governments, and as we know, in the nearest future, probably next year, maybe this year, I hope we will have some basic legislative, basic law about the regulation of virtual assets. So yeah, it's cool things that I will mention, and also really nice to have that conversation with so many specialists who today meet on that Zoom channel. So thank you all for that discussion.
Thank you, Evgeny, very much. And we just talked in previous session with Tatiana Gudima about Ukrainian legislation problem because we have no legislation for opposition of our parliament. We have no question because we have no legislation. But now we have a huge job, academic, lawyers, policemen, government on the. We have two different ways. One way is maybe more British way, another way just copy paste from European Union regulation. So Ukraine, one of the motherland of cryptology, and we have wonderful criminology school, and we have wonderful school of detectives, but unfortunately we have a very, very big gap between practice and legislation. So that's why maybe one of the point of our event today to show our expertise in this and show British way in these cases and show about its realistic practice, and we can work in 24 hours for frozen assets. We have everything for it because Ukrainian crypto market, one of the biggest and all teams in the world in main companies in crypto markets has Ukrainian part, Ukrainian intellectual part. So it's not my political speech. Return to our questions. If there a problem, what successful solution do you offer? For example, what you think we should change it in regulation in UK, because what we should change it in regulation in Ukraine for faster, for better working in this field. What you think we can change it maybe in international level, maybe for best communication between different governments, between different court legal teams?
I'll start this conversation off because we could be here. I mean, how long have you guys got? This could go on for a while. I don't think, just in the wording of the question, I don't think it's necessarily the responsibility of the UK lawmakers to take the weight and burden of making sure we have any kind of international or global alliance when it comes to this. I believe that falls a bit more into the responsibility of the FATF, and I think that it's a double-edged sword. You know, they set out, you know, the obligations, and each jurisdiction has to take their own spin on it, and they get graded on that, listed. You know, we've had a few of the more non or colourful jurisdictions that have been, you know, either taken off the grey list or you know, re-invoked in their positions. Just to something that's I've been part of recently. On Monday, I was actually part of the Digital Commonwealth, the first series that was put together by a gentleman called James Bowater. We were in Mansion House around Bank in London. It's a very nice setting for the kind of coalition that they were looking to put together. But the approach they were taking, you know, they brought together legal professionals, policymakers, regulators, lords even, and MPs to try and sort of establish a similar route to what we've taken, you know, through the Commonwealth with common law, which is British law, which resonates through obviously all of the membering states of the Commonwealth. And that was the first sort of large collective of people that and professionals that I'd been a part of, which were all sort of singing from the same hymn sheet. You go to a lot of these events and it's really, you get a lot of the same panels and talks where people are like, oh, when the regulations come in, when this happens, when that happens, and it's very speculative and opinionated, often with a lot of biases. And the feeling that I got coming away from such an event, as I say, the Digital Commonwealth, was that there are a lot of people in the same position, having exactly the same conversation as we're having now, and trying to establish that. So yeah, it's really, I think that if you look at some of the pioneering jurisdictions, such as Switzerland's, Gibraltar is one definitely to mention as well, and the work that they've put in over the last, you know, sort of 4 or 5 years when it comes to issuing licenses and obviously taking their regulatory stance when it comes to crypto operators. I think there's definitely lessons that can be learned there, you know, that would echo through to UK law and jurisdictional law as well. The one suggestion I could make would probably be for them to have more of a centralized database of information that they can easily, you know, obtain and have those lines of communications. I know there are, you know, other governing bodies that come in and try and do this. Obviously, we've got MiCA coming in this year as well, which will aid a lot of that process, you know, when we're talking interjurisdictional cases or even licensing, providing almost sort of a passport from a licensing degree, which in turn, once again, would make a lot of this a bit easier. You know, without going too deep into the travel rule as well, I believe that these are, once again, all sort of regulatory approaches to making this process easier. But once again, have we got too many chefs in the kitchen? I don't know, but you know, it's really, I think they just need to sort of sit everybody down and create, whether it be laws or policies that, you know, are a common collective between different law enforcements and different jurisdictions and different regulators, that you could kind of set some sort of guidelines which would improve the processes, but not taking anything away from what has already been achieved and the way that it's moving. Definitely a lot better position than what we were in 2 years ago. I think that's probably a good way to say it.
Thank you, Paul. Maybe someone else will have some ideas about future regulation.
I think Paul is absolutely right that some kind of coordinated international approach would be really helpful. But in many jurisdictions on a national level, regulations are there in terms of AML, KYC, countering terror finance, consumer protection, investor protection. A lot of the regulations exist because they've been put in place for the conventional finance sector. But there is a certain culture in crypto of mocking those regulations, and we see that in the kind of court filings that eventually come out when the regulators do get around. So there's kind of a certain level of that the regulators that already in countries that have strong regulations need to enforce those regulations, and they were very slow to start doing that. And secondly, that the crypto exchanges need to take those regulations seriously. You know, when you go to all the trouble of getting that disclosure order and you think you're going to find out who your fraudster or your scammer is, and what you get is kind of fake or incredibly partial KYC data, and you just, you know, there is a certain like culture problem that needs to be sorted out within the crypto exchanges to kind of bring them into compliance with the existing regulations, and then we can build on that and kind of connect those globally to address some of the cross-border money laundering.
Oh, thank you very much. From client position, main question for Ukrainian clients, of course, because we have different mentality of clients. How fast you can organize for me freeze order? months, 2 months, 4 months, 6 months, because in Ukraine we have no any rule for court for this case, just for freeze order. Maybe from your practice, because in Ukraine, if you chose Ukrainian jurisdiction for this cases, it's impossible to understand. And next steps, you cannot make some forecast for future in terms. From your experience in UK jurisdiction, which terms for first main important action? It's international freeze order.
From the, sorry, in terms of the overall timescale for obtaining the freezing order, it can be very quick. There's usually a few days in which the preparatory work is carried out, but the way in which an injunction is issued in England and Wales is that you attach your supporting witness evidence. So there's no cross-examination. Well, there's no cross-examination because of threat actors, but there's no examination of the evidence in court. There's no requirement for the parties to attend. It is usually legal counsel and solicitors present in court. The threat actor can attend if they want to. I'm yet to see one turn up at court, even in cases with significant interest in the press. I would look at a hearing being listed within, we have to give 3 days clear notice. So I'd look listed within a week. That would determine whether there was an interim injunction. Then you would have a subsequent hearing for a final injunction, which is likely to be within 2 to 3 months, subject to court availability. That's based on recent experience in the London courts. I am based in Manchester and use the Manchester High Court a lot as well, and I suspect they will run to a similar timescale. How that fits into the investigation piece, though, the investigation piece is done prior to that, and we will be relying and utilizing the forensic reports that we have at that time. So I think the others can probably speak better to that timescale.
It's very fast. It's very fast.
Yeah. It's not like that for most litigation, but when it's a freezing injunction or an injunction to restrain, then the court is pretty well equipped to deal with it. There's high court judges available.
I think that also, sorry, just to add, I think what you mentioned, in terms of doing the investigation into the case to say, let's say, is it a clear cut, a doozy, that often makes that process a lot faster as well. I think as well, going back to just mentioning the problems, I think if we look at this from the exchange side, like we mentioned as well, if there were regulatory obligations in place where they have to keep those channels open, because the communication with the exchange is not something that is regulated in these stances. And going back to a point that Nick made earlier, some of them give 24 hours if you're lucky. One more recent case I've just been dealing with was 48 hours, so I felt extremely privileged. But we weren't even 100% sure that they were going to keep to that. Obviously, we were monitoring the funds. But what we did notice, obviously, with the exchange themselves, they can be registered in a number of different jurisdictions. And what that can mean, excuse my background.
Very difficult question for maybe end of our beautiful conversation. If you chose transborder case and you prepare some legal opinion about chose UK jurisdiction and another, which your recommendation about if you make some corporate structure for company in crypto market? Okay, we understand in English law, better law, but if we will build corporate structure for different assets, crypto assets, maybe you have some opinion about another, maybe Cyprus, maybe Portuguese, maybe United States, which maybe from your practice better for communication between different teams of lawyers, of courts, of investigators better. I understand it's maybe not clear question.
Sorry if that was just to clarify. No, go on. You
interrupted by the dog. Postman turns up at funny hours here. It's hard to say. I think, going back on where the entities are actually registered will depend also, from the traditional side, how they deal with these kind of matters. Like I say, it comes down to also the licenses that they have in place, because in some jurisdictions there are a number of different licenses you have as a VASP or as a trading license, a commodity, whatever it is that you're involved with and are offering as financial services to potential institutions and even retail users. Probably defines how much longer that takes, because they've got more to look into when there are the different types of licenses. But I'd still put UK top of the list, I think, to a certain degree in turnaround times. But there are, Switzerland as well. Some things happen very quickly with FINMA that I've seen in the past. It's a little bit of a mixed bag. I'll leave it on that one from my side.
Well, I would go maybe for Europe. Now we expect MiCA to come into force in June, and then the FURI in December. Of course, I expect many countries will not follow the deadlines, and it might take another 1 to 2 years when the country will fully be compliant with MiCA. But once you are registered and you are in the European Union having a MiCA license, meaning it's easy to passport your services to all of the European economic area. And the legislation looks to be quite comprehensive, with a good protection of consumers, investors, legal clarity, etc.
Well, thank you very much. Maybe someone have some ideas and words about our topic, because I collect a few questions for our next session about international policy in the crypto markets, and it's very smart idea about Switzerland, because we'll have in next session expert from Switzerland, Ukrainian Switzerland lawyer, and also in this case. So our panel discussion going to end. So maybe you have some words or some recommendation for Ukrainian lawyers and Ukrainian businessmen who or individuals who try working with cryptocurrency. Be pragmatic.
Without fear of repeating one of my earlier points, have a risk management plan in place. Know what to do in the event of a crisis, and it will save you valuable time if there is one.
I would say to Ukrainian business that before contracting with someone or agreeing to their investment service, etc., please check what is the company, if it's licensed or not, just to avoid any problems in the future.
That's a very good point. I'd follow up to say, do your own background checks, your due diligence. First point of call would be ask, do they have legal representation? Do they have a compliance team? And are they licensed before you go anywhere near them or get involved in any kind of way?
Absolutely agree with all of that my co-panelists have just said. Really understanding the background and the track record of who you're dealing with, and how they view regulations and whether they have that compliance in place. Having your cybersecurity team, in place, and having done the kind of preparation on the cybersecurity side, all of that is really important. That's it essentially. I agree. So thank you very much, Alexander, for a great panel.
Thank you, Philippa. Thank you, Caroline, Paul, Nico, and Evgeny for your conversation. For our colleagues and participators who now are in air, if you have some additional question, you can send in chat or in my mail or email for organizer with Zoom links, which you received today. So our wonderful and very professional and very difficult conversation is over. Thank you very much, and see you soon with new cases, with new question or request from our clients. Thank you. You all.
Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you so
Great
much.
to be on the panel as well. Thanks, guys. Great spending the time.